And our closing speaker this afternoon is John Mitchell from Thompson Hine in Cleveland. John is a partner in the firm's product liability litigation, white-collar crime, and business litigation practice groups. As an experienced first-chair trial lawyer, he has tried many significant high-profile criminal matters to verdict in federal and state courts throughout the United States, including approximately 50 jury trials and dozens of bench trials in his career. John regularly counsels public and private companies and individuals facing unwarranted and unwanted government scrutiny, as opposed to warranted government scrutiny, I guess. Or wanted, yeah. He has conducted numerous internal investigations, and his practice regularly brings him into contact with the DOJ, EPA, SEC, IRS, and numerous other federal and state agencies. John will talk about the changing face of obstruction of justice. John?
Thank you very much. Today I sat through this presentation and heard some very good presentations that demonstrated the amount of considerations and daily concerns that most in-house folks have on their plates. And it's a tremendous amount. And here at 3:20 in the afternoon, I'm going to add to that, unfortunately. But with what we've seen with regards today to the way that obstruction of justice is examined by the Department of Justice, the way that it's employed by the various assistant United States attorneys throughout the United States, and the roll-ups and other prosecutions that we heard discussed earlier during the presentations, I think it's important to have a clear understanding of what used to constitute obstruction of justice today is something that is much broader and much different than what we've seen. And I'm going to talk today a little bit about Title 18 U.S.C. 1519, which is a change to the obstruction statute. And I'm going to tell you a little bit about how it's being used and why I think it's something that you need to be aware of, particularly in today's environment of compliance, cooperation, and governmental scrutiny. So let me begin at the beginning then. Now, this is the first time I've ever begun any presentation with a slide of Sarah Palin, and to your credit, half of you didn't stand up and cheer, and half of you didn't get up and walk out the back of the room. But what happened to Governor Palin in the 2008 presidential election kind of underscores how 1519 is being applied across the board in the United States. I don't know if any of you have ever heard the name Jeffrey Kernell, and if you hadn't, you shouldn't be surprised or disappointed. But in 2008, Jeffrey Kernell was a college student in Kentucky who went online to brag about how he had hacked Governor Palin's private Yahoo account. He hit the blogs, as college students are want to do today. He bragged to all the friends within his virtual and electronic community, talking about how he had access to stuff that no one else had. Most of the people seemed to support his actions and pleaded with him to share the information he had, though one, perhaps the only Republican in that chat room, indicated what he was doing was wrong, blocked access of Mr. Kernell to Governor Palin's private email account, notified the Palin campaign, and contacted, or at least indicated to Mr. Kernell that he was going to contact the FBI. Well, what did Mr. Kernell did? Well, he did what any 20-year-old or 21-year-old college student would do. He immediately deleted all the emails that he had. But in today's environment, I think everybody understands what's electronic is often there forever. And after the execution of a search warrant and forensic analysis of his computer, the government was able to locate the emails that were involved. Now, I want to make sure there's two things here that you consider. One is that none of Governor Palin's emails were ever disseminated. The private information that Mr. Kernell had hacked remained private. But the other thing you should consider is the federal government charging Mr. Kernell, charged him with unlawful computer entry, which I think everybody can understand, but also charged him with 18 U.S.C. 1519. Obstruction of justice. Now, I'm going to talk about that for a second, because if you look at the second slide, and this is somebody we talked about in the white-collar crime breakout, this is Rosemary Woods. She was the secretary during the Nixon administration who was famous for deleting 18 minutes of conversation between President Nixon and Bob Haldeman that was germane to the Watergate investigation. And when we think of obstruction of justice, this is the behavior we think of, right? The deletion of emails or the deletion of tapes, the shredding of documents, telling witnesses to lie, and really what is a conscious effort to hamper or impede or affect a pending governmental investigation. And when we look at the common law and the statutes involved typically in obstruction-related behaviors, obstructing the due administration of justice, obstructing the function of a governmental agency, tampering with a witness, they always involve a conscious effort to impede or undermine or deter an ongoing federal investigation. And any amount of obstruction was always enough under these statutes to prosecute for obstruction of justice. But they all had one nexus that was required, and that was they had to obstruct an ongoing and existing proceeding. So you had the obstructive behavior, and then you had the second component, which was the ongoing or existing investigation or governmental proceeding. Well, we all remember this case, right? And when we think of obstructive behavior, Martha Stewart. Originally, she was investigated as part of the Imclone securities trading case. And while the government felt that they could not make a case against her for receiving insider information, when she went in and proffered to the assistants and the FBI handling that case, they determined that she had lied. She was prosecuted for obstruction of justice. The fact that they couldn't prove the substantive offense really had nothing to do with the prosecution in this case. It was for lying, and when convicted, she served a short period of time in prison. Now, stop for a second and think about Martha Stewart and Rosemary Woods and other obstruction cases, which frankly are very, very common these days. And when the government can't make the substantive offense, they immediately start looking at the behavior of those individuals who are under investigation. And let's go back and let's contrast that with our college student, Jeffrey Cornell. Well, Mr. Cornell didn't lie to anybody. He didn't lie to the FBI. He didn't commit any false or offer any false or misleading statements. Frankly, he didn't do anything other than delete the emails after being told that someone was going to notify the FBI. And in today's world, I think we can agree that deleting emails is really the electronic equivalent of shredding documents. And because of those actions, 18 U.S.C. 1519 was brought into play. Now, we remember Anderson, we remember Enron, and we remember how Sarbanes-Oxley came into being as a reaction to the behavior of those corporations during those investigations. And 18 U.S.C. 1519, obstruction of justice, was enacted with little debate and very, very, very little legislative history. But let's talk about what it tells us. 18 U.S.C. 1519 prevents the destruction, alteration, or falsification of records in federal investigations and bankruptcies. And it indicates whoever knowingly alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry in any record, document, or tangible object with the intent to impede, obstruct, or influence the investigation. Now stop right there. That first portion of that statement, which is in black on your screen there before the red, seems to really capture what is an obstructive offense and what is obstruction of justice. But let's go to the red portion. Or proper administration of any matter within the jurisdiction of any department or agency of the United States. And that's certainly, I would argue to everyone in the crowd today, significantly broader than merely obstructing an existing investigation. And it goes on to say, or in any case filed under Title 11, or in relation to or contemplation of any such matter or case. Now think about that. Or in relation to or in contemplation of any such matter of case, or matter or case. And think and ask yourself, how many of you can predict what the government's going to do on a daily basis? Well, 1519 is suggesting that we should be able to. If you look at the intent requirement, it becomes more nebulous. Okay, look at number 1. The defendant knowingly alters, destroys, mutilates, conceals, covers up, falsifies, ... with intent to impede an investigation or proper administration of a federal matter. Okay, I think we all get that, right? I mean, that's obstruction. Somebody shows up and with a badge and says they're investigating something, and you start lying, and then you go into your computer room and you pick out a sledgehammer and you smash your IBM and you run for the border. I think we can all agree that that would be obstruction. Now look at number 2, though. A defendant in contemplation of a federal matter. Now, what does that mean? I think well, most of us say, well, maybe we're going to have an interaction with a federal agency, maybe we're going to, we're going to file our taxes or something like that. Knowingly alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry, ... But then look at number 3, a defendant in relation to a federal matter. Now what does that mean? Well, it seems to be different and broader than in contemplation of, but it's certainly broader and beyond what is identified in his traditional obstruction behavior that we see when impeding an investigation or the proper administration of a federal matter. Well, we've gotten some guidance from the folks who wrote this. What Senator Leahy tells us, or told us at the time, is that this statute is specifically meant not to include any technical requirement which some courts have read into other obstruction of justice statutes, to tie the obstructive conduct to a pending or imminent proceeding. Okay, well, I would suggest to you that in the legal context, the word imminent can be a dangerous word. I mean, what does imminent mean to the government? They tend to operate on a different schedule, one that's a little slower than corporate America and most of the law firms I've encountered in my career. Senator Leahy continued when he said it is also meant to do away with distinctions, which some courts have read into obstruction statutes, between court proceedings, investigations, regulatory or administrative proceedings, whether formal or not, and less formal government inquiries, regardless of their title. So what's the significance of this comment? Well, this tells us that the chairman of the Senate Judiciary Committee at the time this statute was put in place feels that under 1519, less formal government inquiries carry every bit the same weight as investigations and regulatory proceedings. Senator Leahy continued when he said it also meant to do away with, it also extends to acts done in contemplation of such federal matters, so that the timing of the act in relation to the beginning of the matter or the investigation is also not a bar to prosecution. The intent of this provision is simple. People should not be destroying, altering, or falsifying documents to obstruct any government function. I think we can all agree that is a good thing. But the manner in which this being broader than an existing investigation, the fact that timing is no longer really relevant under 1519, takes something that we associate with Rosemary Woods and Martha Stewart and those who lie to the FBI when they show up on their desk to an area that is much broader, much more open, and completely new with regard to obstructive behavior. Let's talk about a few examples here, and there's a point I want to make. U.S. versus Rhodes, falsification of a use of force report. After privately contracted prison guards assault an inmate constituted a 1519 violation. Moyer, falsifying police reports related to racially motivated attack constituted a 1519 violation. Gray, omission of a chokehold from a use of force reports constituted a 1519 violation. There's Cornell, deletion of traces of hacking, and then there's Reeves below that talks about the interplay between the Lacey Act and 1519 and how, since the Lacey Act had its own significant obstruction penalties, that 1519 couldn't be brought in. But let me stop you for a second. And everyone's saying, these are all about police reports and false records submitted by prison officials. And what does that have to do with the financial services market? Well, take a step back and say, why was this provision enacted to begin with? It's part of Sarbanes-Oxley. Yet look at the way and the manner that it's being applied by the federal government. And the reason I'm standing before you today to discuss this statute is because in representing individuals that are facing unwarranted governmental scrutiny, 1519 is one of the things that readily rolls off the tongue of today's assistant United States attorneys. Even though, as you can see from the case law, that's very limited, that it's not applied in any way that is supposed to prohibit the behavior prohibited by Sarbanes-Oxley. Now, there were some voices out there that discussed how 1519 could be construed so broadly and how that is troubling. And I'm not going to read all this, but I am going to show you a portion. says, we have voiced our concern that Section 1519, and in particular the phrase, or proper administration of any matter within the jurisdiction of any department or agency of the United States, could be more broadly interpreted more broadly than we intend. In our view, Section 1519 should be used to prosecute only those individuals who destroy evidence with the specific intent to impede or obstruct a pending or future criminal investigation, a formal administrative proceeding, or bankruptcy case. Now think about that statement there and the earlier case law that we showed you in our presentation. So why are we here? You know, again, I saw this quote online and it always stuck with me, and that is, the fundamental problem with expense reports is that if I'm going to have to work so hard on fiction, I should at least have gotten a book advance. And it's said tongue-in-cheek, but I'm sure all of you who are in-house have encountered the overzealous and adventurous salesman who submits his reports, the engineer perhaps who wants his results to be better than they should have been, the careless employee who is dumping things that perhaps they shouldn't be. And I understand all those things are things that are on your plate that you have to consider. But if you look at obstruction of justice under 1519, it carries with it a 20-year sentence. And if those submissions that are made in-house by your employees ultimately are moved or sent to the federal government as part of an EPA review or the IRS inquiry or the SEC, or somebody starts poking around, 1519 comes into play. And the significance of this obstructing offense is, if you look at the federal sentencing guidelines and you go to 1519, you flip and you go straight down that chart, you start at an offense level 14 without any exacerbating factors, which puts you in a zone D, and a sentence of 15 to 21 months. And unless you receive some non-guideline sentence, which only happens in about 1 out of every 6 cases, that person's going to go to jail. So I think if we sat down today and I started polling people, you could come up by the end of the day with 100 different ways that this statute could be used when your corporation is interacting with the federal government and someone within that corporation has submitted false or misleading information. And again, that's not to suggest the corporation is liable. But if you ever have time and you're ever in the position of training your employees and avoiding headaches and making sure that we're compliant and respectful of what the federal government is trying to do, laying out that 1519 is out there, it exists, and it's being applied with more and more frequency. It's being applied broader than it should be, perhaps, and in ways not intended by those authors of that statute, would suggest that's one thing, hopefully, that might cause people to take a second, think about what they're doing, and making sure that they comply with our internal regulations and with the laws in which they've been trained. Thank you for your time.